know that even though trials are fluid, the fact of the matter is we do not do trial by ambush in this state. Okay? There's a right to discovery. And you may be in a position right now where you may be waiving, and I'm trying to look up the case right now as we speak since this is a new issue, and the court didn't have an opportunity to prepare. You may be in a position where if you're putting Mr. Wasser on to say this, that you may actually be waiving attorney-client privilege. I need to do a little research on that. But and I also find it very interesting that you're only turning this over at 3:45 in the 3:45 in the afternoon when this was asked to be done yesterday. You should have brought it to everyone's attention that you were going to attempt to do this so everybody could have prepared for this moment in time.
Judge, if you want, we can recall David. We can call David Wasser tomorrow. I can call Mr. Medina's father next, who's our next witness, and we can move forward.
Okay, if that's what you would like to do, I'm fine with that.
I'm asking the court if
I'm not here to tell you how to present your case. I'm here to make sure that both the state and the defense get a fair trial.
And I will say this, Judge, we contacted and contracted Mr. Coleman to present 6 videos. One of the videos, we were under the assumption that was candid, that we hired him, he told you, to slow down the video and to enhance it. He enhanced it. We were under the impression that that video would have a slowdown section. He testified to it. Unfortunately, it doesn't. I believe he forgot to download the most important piece of evidence in terms of what we're discussing for this conversation. So we will be recalling Mr. Coleman. And
well, it sounds like, State, do you have a copy of this slowed down version? So you need to prepare a copy to them.
That's the only slowdown video, and I'm looking at what's been admitted as I believe defense is C, which is currently up on the monitor. The only slow motion video is labeled jump back slow motion. And I did have that video. I did have that at discovery. I have no other slow motion video here.
Judge, if you recall yesterday,
no, it's not the same
there was a very extensive debate over the disc that was presented. There were lots still, and what the defense agreed to do was to take the exact disc that had been provided by the defense with the pretty U.S. forensics label from the state and say, you know what, we're going to use just that. That was defense counsel's suggestion to end everything that was going on. And so we said, fine, make a copy of just that, and that's all we needed to use.
She's 100% correct, and that's because I was under the assumption, incorrectly, that that portion, the events in the kitchen Zoom, the events in the kitchen side by side should have been slowed down. What I'm going to do is I'm going to ask Mr. Coleman to do that, make myself a copy, make the prosecution a copy, and then we will hold off on calling him near the conclusion of our case so it affords the prosecution the appropriate time to send it to their forensic team to do their due diligence. And if they need to talk to him or ask him any follow-up questions, we have no problem doing that, Judge.
So when will we be getting that?
We're working on getting that right now, Judge.
We reserve the right to make any appropriate objections when it is.
Correct. Okay, what does this defense wish to do at this point?
Judge, can I confer with my client?
Of course you may. Is that where you have the envelope? Yes, I do.
So, Judge, this is what I'm going to propose to do. I think this is an equitable resolution. I will call Mr. Wasser, and I will not venture into the items that are at issue with regards to what's previously marked, pardon me, I'm sorry, as A10 and A5. I will allow the prosecution time to do their due diligence, allow them time to do whatever they need with their forensic unit to make a determination of the validity of this, with the right to recall Mr. Wasser later. We have listed a crime scene analyst, and Daniel Schumacher. Yeah. And what we will do is we will have Mr. Schumacher, who we will present in the cessation of our case. Well, this is what I'll say, Judge. Why don't we do this? We'll call Mr. Wasser. I won't address these issues until I will give the prosecutor. I'll hold off on recalling Mr. Wasser until near the conclusion of my case, to afford them the ability to do their due diligence with regards to the video. We're in the process of contacting Mr. Coleman, which will send us the slowed-down video of the side-by-side of the kitchen. The second I get that, I'll give the prosecution a copy of it, and then I will also hold off on bringing him back down until near the end of my case, if that's what they want.
That raises another concern. That the only other issue that Mr. Watson was with regards to the bottle of pills that were found just days later. That's the only other area, and we don't believe that a foundation for admissibility of that evidence has yet been laid. There's been witness established that those pills were present, that they were possessed by about them, etc. So if Mr. Wasser is going to come in here and testify not to this, the only other thing he can testify to are the pills, and it's our position there's no foundation yet.
We'll lay the foundation, Judge. I'll let you know. I'm not going to bring in any evidence through him. I'm just simply going to get his testimony as to what he did. He's not going to make any testimonial statement with regards to what the substances were. He's simply going to get in here and say, I was the investigator. He's going to describe what he did in terms of his investigation in the house. And he's going to be able to testify that a month or so later he discovered these white pills that he didn't know what they were, and then we'll in essence leave it to that, and I'll link it up later, and I'll provide the predicate and the foundation for it later on, link it up, and then be able to introduce it through either Dr. Logan or Miss Alicia, is it Walker? The chemist from NMS Labs, Judge. I apologize. I don't recall her last name.
But without a foundation, the evidence is not relevant. Before it becomes relevant testimony, there must be a foundation laid. That's the whole point.
Well,
the defense just calls Mr. Wasser and says he found some pills 2 months after the homicide. How does that help the jury in fact an issue unless there is some context for the pills?
No. I was just going to...
Okay, defense?
Listen, first of all, Judge, what I meant was that I was going to say that he is going to give a general... I was hired, I did a lot of investigations. I'm not going to ask him for specifics, and then I'm going to direct him to the issue, because here's what's going to happen, Judge, just so to be clear. They're going to ask him a financial question. I have to be able to explain to them how this investigation was done, and it's going to be relevant. If they don't question him about money, I won't ask him what the scope of what he did. But if they question about his fiduciary benefit, then on redirect, I will ask him, because it opens the door to that. That's
I think one is apples and one is oranges.
Potentially.
We're talking about the pills. Why are the pills relevant at this point in this litigation?
Judge, my client, in his taped statement to the police, indicated, as Mr. Dunn so eloquently said, he called his wife a drug addict, a slew of things. So that's an issue. The issue is my client made a statement with regards to the issue that he had with his wife, the fact that she had a history of drug use and abuse. It's there. It's there in the text messages with Kelly Berry Harwood. One of the ones in the early morning is, I'm cleaning, and then there's a suggestion of burst of energy. That could be an implication that she's under the influence of amphetamine. These are things that we are going to be able to make. We're laying the foundation, Judge. He talks about it in the statement. There's text messages with Kelly Berry where there's an allegation that she has a burst of energy. We're going to make the nexus between his statement with regards to his drug use and what's in those text messages clearly brings this issue to light.
Can I see the transcript context of that statement? Because as I recall from I thought at the beginning of Mr. Medina's statement, he makes a statement that she used to be.
It's not in the transcript because this was before the court reporter got set up, because you have to hear that on the video. If you want to watch it, you have to listen to the video. He specifically says, cue it up. He specifically says past drug use. That's what he referenced.
He says, I don't know what she's on now.
And he specifically said, I don't know if she's still using drugs.
Can we put that in, please?
And also, Judge, in reference to Kelly Berry's text messages, it is not Kelly Berry asking Jennifer Alfonso if she has a burst of energy. It is Jennifer Alfonso writing to Kelly Berry because she's talking about how she's cleaning toilets at 8 o'clock in the morning. And Jennifer Alfonso is the one who says to Kelly Berry, burst of energy. Right.
Well, regardless, the
So-
judge understands that they will be in evidence and
Right.
in a good faith.
But they don't support what the
One person
defense
at
is
a time.
relying on
Okay, let me hear
to
the
say that
statement
foundation
first.
has been laid.
Judge, for the record, states in evidence 146 is the video of the statement.
And can I also see, Deborah, not yet in evidence, but was brought in during the perpetuation of the testimony, the text messages, I'll get you the, I think it's
Do
in
you want a
the-
copy? I have a copy if you want.
I believe it's defense A.
Yeah.
Mr. Dunn, when it's queued up, you can just play it.
I did catch her smoking a few months ago, a couple months ago. After she told me she stopped, so I don't know if she was still on drugs, or marijuana, or cocaine, or whatever substance.
That's
But I
right.
know that
Okay, at this time, I'm not permitting Mr. Wasser to testify. He clearly says on the tape, I do not know. It is not yet an issue in this case. And again, in defenses A, for identification, defendant's A2 composition, which is not yet in evidence in this case, but even to link it up, the statement about burst of energy came from Jennifer Alfonso to Miss Berry, then Miss Berry, about the fact that at 8 o'clock in the morning, Miss Berry felt a burst of energy to clean. So at this time, the court is finding that it's not relevant.
I understand, but I just want to point to the court's attention that that statement for her burst of energy came an hour after she went to the exact
But
closet.
Mr. Zagane, Miss Alfonso is saying that to Miss Berry, that Miss Berry, you, Miss Berry, are having a burst of energy. Not I am having a burst of energy. She's saying you are having a burst of energy. Read it.
Right, no, but regardless, if she says she's cleaning at 8 in the morning, so she's making an implication that she's having a burst of energy.
Miss Berry is having a
That-
burst of energy. Not Miss Alfonso. Read that again.
Let me see it.
Read
if I
it.
might,
It's Miss
Judge.
Alfonso saying you're having a burst of energy. And even Ms. Berry, who testified perpetuation, not yet in evidence, she says that that was said to her via text message. So at this time, the court's making a ruling that it is not yet relevant.
Regardless of the text message, Judge, so your holding is the fact that my client brings it up in his statement the day of the shooting at 6 o'clock in the morning, the video shows Miss Alfonso going into the drawer, pulling out what appears to be from the same exact section that we discovered the pills, that it's not at issue at this case? That's the court's ruling?
As we all just heard, Mr. Medina, in his statement, spontaneously stated and alleged that Miss Alfonso had a drug problem, had said that they had been working on it, that she had not smoked in over a month, and that he did not know if she was using. He did not know. If for you to raise it as an issue, it had to have been in Mr. Medina's mind at the time of the incident.
Judge,
and you have to lay a proper foundation for that. I am not going to allow the defense to make leaps and inferences in this case when Mr. Medina's own words on that tape says he did not know.
I think that it's our interpretation of that he didn't know was because he believed that that was a possibility.
You're making an assumption, and I'm not going to allow assumptions or speculation to come to this jury. You have to present evidence, if you can, that Mr. Medina knew, and that's how you make it relevant. And at this point, it is not yet relevant. Defense, get ready to call your next witness. If anybody needs to use the restroom and prepare, do so now.
Judge, I have another issue with something that the defense raised about another witness. I don't know if you want to address it now or later.
I believe that there's further information in his statement where he says that he believed, my client says in the statement, I believe she was on something. I believe it would play it in its entirety prior to the beginning to the
You have 5 minutes to find it, okay? We'll be in recess for 5 minutes.
They give it back to me, Sam. Sam, they give it back to me.